Growth is never a straight line. Without setbacks, challenges, or plateaus, there's no chance to regroup, reflect, and push forward. On paper, I may look like I have it all together, but in reality, I'm just like everyone else. Overcommitting, saying yes out of fear, people-pleasing, and sometimes biting off more than I can chew. And that's important to acknowledge, because the myth that thought leaders, self-help authors, or podcast hosts somehow hold the keys to the kingdom is exactly that, a myth. The grass isn't always greener on the other side, and reaching a certain milestone doesn't automatically mean bliss or lasting happiness. Now, speaking of things not adding up, let's talk about what's happening in the news. Reports claim that someone was arrested at Travis Kelce's house on September 15th while allegedly trying to serve Taylor Swift with deposition papers. The story says a man jumped the fence at 2 a.m. with subpoena documents. But here's the catch. Taylor's attorney had already filed in court days earlier, stating that if deposition became necessary, she would make herself available. So why would a process server show up at 2 a.m. climbing fences? Most servers I know don't operate in the dead of night. Something doesn't feel right. Meanwhile, in the legal battle between Blake Lively and Justin Baldoni, things are heating up again. Lively has requested sanctions against Baldoni for the third time, invoking California Civil Code Part 47.1. This statute, effective January 1st, 2024, gives protection to those filing claims of sexual harassment or discrimination, allowing recovery of attorney's fees and even treble or punitive damages if their claims are challenged without merit. Baldoni's team, however, calls this request draconian and unconstitutional, arguing that the statute has never been tested in court and could overstep First Amendment rights, as well as protections against excessive penalties under the Fourth Amendment. Here's where it gets more complex. While critics label Lively's move as abusive, it's important to recognize the law's original intent, empowering victims, often women, who lack financial resources or powerful connections to pursue justice without fear of retaliation. For victims without wealth or celebrity backing, this law could be life-changing. The problem arises when it's used in cases outside its intended scope, or in jurisdictions where it might not even apply, like New York and New Jersey, where the events tied to this lawsuit allegedly occurred. Baldoni's response leans heavily on constitutional challenges, suggesting that aspects of the fee-shifting provisions may be overturned while other portions of the statute survive. In short, the law itself might remain, but certain mechanisms could be struck down as unconstitutional. That makes this case not only a high-stakes Hollywood drama, but also a potential test case for a brand new law that hasn't seen daylight in any published decision yet. The bottom line? Blake Lively may be leveraging a statute designed to protect victims, but if courts agree with Baldoni's team, it could backfire spectacularly. Until then, depositions remain sealed. Names like Danny Greenberg and Vivian Baker hover in the shadows, and fans are left watching one of Hollywood's most tangled legal battles unfold in real time. When it comes to Blake Lively's ongoing legal battle, one of the most complicated parts is her attempt to use California Civil Code Section 47.1 as a weapon in her sanctions motion. The heart of the matter lies in whether this statute, which was passed to protect victims of harassment and discrimination, can be applied in this case, in this court, and under these circumstances. To understand why this is such a messy and potentially groundbreaking issue, you need to know what Section 47.1 does, why it exists, and why Baldoni's legal team is fighting so aggressively to keep it from being used against them. Section 47.1 was designed to give victims of harassment, especially sexual harassment, the ability to speak out, file claims, and pursue legal remedies without the looming threat of crushing financial retaliation. It provides what is called a qualified privilege, meaning that if a person comes forward with harassment claims in good faith and without malice, they cannot be punished with massive defamation judgments or retaliation lawsuits just because their allegations were challenged or dismissed. In practice, this statute authorizes recovery of attorney's fees, treble damages, and even punitive damages when a harassment victim's claims are attacked in bad faith. For survivors without wealth, connections, or a powerful spouse backing them, this kind of legal shield could make the difference between silence and justice. That is why lawmakers passed it. But like many new laws, the wording is vague, the scope is unclear, and the courts have never tested it. That's where Blake Lively comes in. She is attempting to use Section 47.1 to secure sanctions against Baldoni and his team, claiming that his defamation case against her should trigger penalties under the statute. Her argument is that she made her harassment claims in good faith, without malice, and therefore any legal counterattack against her should result in damages. But here's the problem. No court has actually determined whether her claims are true or false. At this stage, everything she has alleged remains just that: allegations. Allegations are not facts. Until a court or a jury determines the truth of her claims, the law cannot assume she was acting without malice. That requires findings of fact, something that has not yet happened. Baldoni's team is pointing this out in no uncertain terms. They argue that Lively is asking the court to award damages before any fact-finding has occurred. She wants sanctions imposed on the assumption that her allegations are true, but the court has not ruled on them yet. From their perspective, this is putting the cart before the horse. Until a trier of fact, a jury or a judge on summary judgment, actually rules on whether she was harassed, the question of her motive remains open. Did she bring these claims sincerely, or was there another motive behind them? That determination is essential, and it cannot be skipped. Another major point of contention is timing. Lively claims that for the statute to be effective, its remedies must be available at an early stage, ideally through motions to dismiss. She argues that this is necessary to protect survivors from being dragged through lengthy, punishing litigation. But the statute itself doesn't explicitly say that. The legislative history doesn't clarify whether sanctions are supposed to be imposed after a motion is dismissed or after a full trial. There's no case law to guide the court because the law is brand new. That means this case could set the very first precedent. Baldoni's lawyers argue that awarding damages now would create serious problems. First, it would prejudice any future jury. Imagine a jury being told that Lively already won damages because the court assumed Baldoni acted maliciously. Wouldn't that suggest to the jury that her harassment claims must be true? That kind of influence could poison the jury pool and undermine the fairness of the trial. They also argue that the statute was primarily intended for use in cross-claims, where a victim reports harassment and is immediately countersued for defamation. In this case, Baldoni's defamation claim was not filed as a cross-complaint, but as a separate action that was later consolidated. The statute may not even apply in that context. The defense also spends time highlighting that part of the statute hinges on motive. Was Blake Lively motivated by genuine belief in her claims or by something else? If her motive was retaliation, publicity, or leverage, then she may not qualify for protection under Section 47.1. Baldoni's team insists that her motives were not altruistic, and that she acted with malice, or at least without good faith. They emphasize that while the court dismissed claims against Ryan Reynolds and publicist Leslie Sloan for failure to plead malice, no such determination has been made about Lively herself. That leaves her wide open to scrutiny. Their overall argument boils down to this: Lively's motion should be denied because she has not proven, and no trier of fact has found, that her claims were made without malice. She has not presented new facts or new law to warrant reconsideration. She has not shown extraterritorial applicability of the California statute in a case centered in New York and New Jersey. She has not shown compensatory damages that would be required to calculate treble or punitive damages. And fundamentally, she is asking the court to accept as fact allegations that remain unproven. There's also a procedural angle. When you lose a motion in court, you can file for reconsideration, but only if you present new facts, new law, or a change in circumstances. Baldoni's team says Lively has done none of this. Instead, she is recycling the same arguments and facts from her earlier filings, repackaging them as if something has changed. In their view, this is nothing more than an improper request for reconsideration, possibly designed to sway public perception or taint the jury pool by keeping her narrative alive in the media. They suggest that her renewed motion is a thinly veiled PR tactic rather than a legitimate legal maneuver. If the judge agrees with Baldoni's framing, Lively's motion could be rejected as premature. The court might also decide that California courts, not a New York federal court, should be the ones to interpret and apply a brand new California statute. That would be consistent with general legal principles, since laws are usually interpreted first by courts in the state where they were passed. But if the New York court does weigh in, its ruling could carry enormous influence, because it would be the first published decision interpreting Section 47.1. From a broader perspective, this case raises serious questions about how far courts should go in protecting harassment victims, while still respecting the rights of those accused. On one hand, statutes like 47.1 are necessary to prevent silencing tactics that discourage survivors from coming forward. On the other hand, applying such statutes too aggressively, too early, or in the wrong context risks undermining due process and tipping the scales unfairly. Lively's critics argue that she is abusing the law, using it as a sword rather than a shield. Instead of simply protecting her ability to speak out, she is allegedly trying to weaponize it to crush Baldoni before the facts are even established. Supporters, however, may argue that early remedies are essential, because survivors often endure years of costly, exhausting litigation designed to break them financially and emotionally. That tension, between protecting survivors and preserving fairness for defendants, is at the heart of this legal drama. The longer this case drags on, the more complex it becomes. Every motion, every filing, every procedural twist raises new constitutional and jurisdictional questions. Can California law reach into New York federal court? Should punitive damages be awarded before a trial? Can a statute designed for cross-claims be applied in consolidated cases? And perhaps most importantly, what was Blake Lively's true motive in bringing these claims? Baldoni's lawyers are giving the judge multiple outs, multiple arguments to lean on. If the judge doesn't buy their jurisdictional argument, maybe they'll accept the procedural one. If not the procedural, maybe the timing. If not timing, then motive. The defense is laying out a buffet of reasons to deny Lively's motion, hoping at least one will stick. And in doing so, they are reminding the court, again and again, that allegations are not facts. No jury has ruled. No trier of fact has found malice or lack thereof. Until that happens, awarding damages would be premature, prejudicial, and potentially unconstitutional. This is why the stakes are so high. This isn't just about Blake Lively and Justin Baldoni. This is about how far Section 47.1 can reach, how courts will interpret it, and whether it becomes a powerful tool for survivors or a weapon for celebrity litigants to silence critics. If the court sides with Lively, it could embolden others to file similar motions early in their cases, reshaping how harassment lawsuits unfold. If the court sides with Baldoni, it could limit the statute's reach and force future litigants to wait until trials conclude before seeking damages. Either way, this case will echo far beyond the Hollywood gossip mill. And so we wait. We wait to see if the court will allow Lively's motion, deny it as premature, or punt the issue back to California courts. We wait to see whether the allegations against Baldoni are ever proven or disproven at trial. We wait to see how the media continues to spin the narrative, and how much of that spin is orchestrated by PR teams behind the scenes. For now, one thing is clear: nothing has been proven. The only facts established are that allegations exist, motions have been filed, and a brand new law is being stretched to its limits. When we step back and really consider what is happening in this legal battle, the core of the argument is relatively straightforward, yet the way it plays out in court makes it complicated, emotional and draining for everyone involved. Their entire defense hinges on the fact that Blake Lively's harassment claims are still pending. That is critical because until those claims are fully tested in court, until a jury or a judge makes an actual finding of fact, they remain just that: allegations. Allegations are not facts, no matter how loudly or forcefully they are presented. The merit of her claims, the intent behind them, and the motive with which she filed them are all issues that have not yet been decided. And those decisions, by law, belong not to the press, not to public opinion, but to a trier of fact, a jury in a full trial, or a judge in a summary adjudication process. This is a fundamental principle of justice. Allegations must be tested before they are treated as truth. A centerpiece of the Wayfair defense, and Justin's defense, is that Blake's claims lack merit. They believe strongly that her filings were not only exaggerated, but were submitted for an improper purpose. In their view, she is not an altruistic victim coming forward with genuine experiences of harassment, but instead someone motivated by other interests, whether it be power, leverage, or control. That is why their attorneys keep stressing the importance of motive. Because in many of these statutes, particularly the California law she is trying to use, the issue of malice matters. A claim is protected if it was brought without malice, in good faith, with a reasonable basis. But if malice is shown, if the court finds that the accuser acted with ill will, spite, or ulterior motives, then the protections fall away. This is not a simple question, and it is not one that can be resolved in a quick motion. It has to be tested with evidence, testimony, and cross-examination. And that is why the defense is pushing back so hard against her attempts to secure remedies before the merits are even tested. Think about it. If the court were to grant her requests now, it would be essentially making a premature finding of fact. It would be saying, yes, we accept that her claims were brought without malice, even though the defense hasn't yet had the chance to present their side. That is exactly what Justin and Wayfair are arguing against. They are saying that to rule in her favor at this stage would rob them of their right to defend themselves, to present evidence, and to let a jury weigh the truth. In other words, it would shortcut the process of justice. Courts are very careful about not doing that, because once you make a factual determination too early, you risk prejudicing the entire case. Now, another complicated layer here is the fact that she is asking a New York court to apply a California statute, Section 47.1. Right away, that raises jurisdictional issues. Laws are usually designed to apply within the state in which they were written, unless there is clear legislative intent or precedent to apply them more broadly. Here, the conduct at issue did not even take place in California. Much of it occurred in New York and New Jersey. So the defense is pointing out that it's not even clear that this law can be applied extraterritorially, meaning outside the state's borders, especially to non-residents. This is a very strong argument because courts are typically reluctant to extend state-specific laws into other states' proceedings unless Congress or a higher authority has said they must. A New York judge sitting in federal court may very well decide not to touch this issue precisely because it is so murky. I've watched lawyers break this down on social media, on TikTok, and in other forums, and many of them agree that the judge is unlikely to wade into this gray area. Judges generally prefer to stay within clear lines of authority, and deciding whether California's statute applies in New York to conduct that happened in another state is not a simple, clean question. Many believe the judge won't touch it with a 10-foot pole, and I tend to agree. Now let me connect this to my own experiences, because I think it helps illustrate just how emotionally exhausting and destabilizing this kind of legal strategy can be. I have personally been in lawsuits where false allegations were made against me in court filings, and I can tell you from lived experience how powerless that can make you feel. Just recently, I shared with my audience that I am in the middle of a lawsuit connected to a man named Robert Shin. This is a person who, according to federal investigators, is facing inquiries from multiple agencies: the FBI, the IRS, the Department of Labor, the United States Postal Service inspectors, and those investigations center around extremely serious allegations: sex trafficking, human trafficking, forced labor, mail fraud, bank fraud, and tax evasion. Federal agents even executed a raid on him in July of 2025. His church was featured in a Netflix documentary series, and I personally was involved in helping bring that story forward. Yet despite all of that, despite the mountain of scrutiny he is under, he has turned around and filed lawsuits against me. And in those filings, he paints me as the villain, the malicious actor who is out to ruin him. He claims that I fabricated things, that I have targeted him unfairly, that my motives are to destroy his reputation. He even went so far as to claim that the reason his own dancers and followers deleted evidence was not because they were protecting him or responding to federal investigations, but because they were allegedly terrified of me. Think about how absurd that is, shifting the blame away from the accused who is under active federal investigation, and onto me, a reporter and critic, painting me as the danger. That is the kind of weaponization of the court system that I see echoed in this case between Blake and Justin. It is incredibly draining to be the target of such tactics. I have spent over 3 years in this exhausting cycle. It wears you down emotionally, mentally, physically. It takes away joy. It leaves you feeling unsafe in your own home. I have cried more times than I care to admit because the weight of it is crushing. The fear of harassment, the constant doxing, the relentless attacks, it leaves you exhausted. And so when I look at Justin's situation, when I see the way Blake keeps filing motion after motion, I can't help but feel empathy. Because I know what it is like to be on the receiving end of that barrage, to feel like no matter what you do, you are being dragged back into court again and again. Not necessarily for justice, but for strategy, for retaliation, for PR purposes. And I want to make this clear. When someone wants accountability for wrongdoing, that does not automatically mean they are acting with malice. If a person is guilty of crimes and is sentenced appropriately, hoping that they face the full consequences is not malicious. It is justice. In Robert Shin's case, one of the charges he faces carries a potential life sentence. He is already in his late 60s. If convicted, it is very possible he could spend the rest of his life in prison. When I said I hoped he would die in prison, I meant simply that if he is guilty, accountability should mean serving the full term, which given his age, would likely be until his natural death. That is not malice. That is a call for justice. And yet in his filings, he twists that sentiment into evidence of my supposed danger, of my alleged hatred, as if I am some unhinged actor. That is the danger of how words and motives can be distorted in litigation. That is exactly what the Wayfair defense is worried about here. They are concerned that if the court grants Blake's motions now, it will essentially allow her to weaponize the process, to poison public perception, to shape the narrative before the facts are even tested. They argue that her renewed motions are little more than thinly veiled attempts at PR spin, dressed up as legal filings. And I see the same playbook at work in my own life, regurgitating old arguments, filing motions that aren't truly supported by new evidence, and ultimately trying to win in the court of public opinion rather than in the court of law. That is why I can say with confidence that this is not a traditional case. It doesn't feel like a straightforward dispute where the facts will simply come out and justice will be done. It feels more like a PR war, a mudslinging contest being fought in parallel with the courtroom. That is why so many of us watching from the outside feel unsettled, disconcerted, even frustrated with the process. We look at the rulings and feel that justice is being delayed or distorted. We see the filings and sense that the motives are not pure. We want to believe in the system, but when it is weaponized by those with power, influence, or resources, it becomes harder to trust. Now, do I know how this will end? No, none of us do. If it goes all the way to trial, anything could happen. A jury could side with Blake, a jury could side with Justin. The truth could emerge in unexpected ways. But from where I sit, Blake's filings don't look strong. They look retaliatory, strategic, and repetitive. They remind me too much of what I have personally lived through with Robert Shin. And that is why I've devoted so much energy to covering this case, because I can see the patterns. I can recognize the tactics, and I know the toll they take. At the end of the day, all of these people, Blake, Justin, the attorneys, even the followers who are wrapped up in it, are human beings. They are flawed, they are emotional, they are struggling through an intense legal battle that will shape their reputations and futures.